Hi everyone, welcome to our video presentation. Today we are going to explore a fascinating case which develops inside the wall of a well-known company called Bright AD. I am Bilal Sahak. I am going to guide you how to navigate the complexities of this case study, as it also needs your immediate attention. Four key issues have been identified in this case study, which Sarah went through those cases. The first one is workplace discrimination, user data privacy violation, workplace safety violation, and lastly, workers' exploitation allegations. These issues bring up serious ethical questions and also in addition to legal difficulties. Let's now explore and also find out the reasons behind of these cases and also offer suggestions to those who may be impacted by such cases.
Thank you, Bilal Sahar. My name is Faisal Mahamadou, and today I will be addressing the first issue of our case study. In issue 1, we examine the discriminatory behavior, the discriminatory treatment faced by Sarah, an American Palestinian employee at Bright AD company. Therefore, the question here is whether Sarah has a legal basis to address this discriminatory behavior. Now, let's explore in more details in Sarah's case, our first issue of 4 critical challenges. Sarah's case not only highlights a breach of discriminatory issue, but also highlights the significance of legal provisions like Article 14, 15, and 16 of Indian constitutional law. These constitutional safeguards are the backbone of ensuring equality, non-discrimination, and equal opportunities for every individual, regardless of their background, sex, race, and so on. In Sarah's situation, the key legal question revolves around the violation of these constitutional rights. Now, let us delve into the difficulty of employment discrimination and the legal direction available to address such injustices. The Equal Employment Act of 1976 and the Prevention of Sexual Harassment in the Workplace Act of 2013 provide specific measures to combat discriminatory practices. Therefore, Sarah, as an employee facing such prejudiced treatment, can seek redress through these legal channels. Moreover, it is essential for her to document instances of prejudice, gather evidence, and use legal channels like the Internal Compliance Committee (ICC) to ensure her rights are protected. Following more steps, Sarah not only seeks a compensation for the harm caused, but also contributes a fostering workplace culture that upholds equality and non-discrimination. Therefore, this is the end of the first issue of the case study, and upcoming segments you will hear the other 3 issues that we will talk in this video. Thank you, and let's proceed the other parts.
Thank you so much, Faisal, for your wonderful explanation regarding our first issue. Welcome back. This is Sayyaf Ahmed. Moving forward, now I'm going to delve into our second important issue in our case study. This issue revolves around worker exploitation and unpaid overtime at the Bright AD company. In this scenario, employees have reported being intimidated for advocating better treatment and forced to work overtime without any pay and denied breaks. And in this issue, this issue brings into the question the company's adherence to labor law and the right of workers for better treatment and fair working conditions.
Now, let's explore this second issue in more detail. The heart of this matter lies on the violation of labor rights, particularly in terms of the Indian Minimum Wage Act of 1948, as we comparing this issue with Indian Constitution. This piece of legislation aims to ensure fair compensation for laborers, preventing worker exploitation and reducing poverty and inequality. As we navigating through the complexity of this issue, we will also touch upon the challenges in enforcing and covering the Minimum Wage Act, shedding light on the need for better regulation, training, and compliance to safeguard the right and well-being of workers, especially those in the informal sector. And it is crucial for employers to gather evidence, use the provision of the Act, and demand fair treatment and working conditions.
By doing so, the employees, especially Sarah, she can contribute to improve her circumstances and holding the corporation accountable for any labor law infractions. So to conclude my presentation here, our exploration into the challenges faced at the Bright Ed company by Sarah continues. So stay tuned as we examine the intricacies of our fourth and third problems. Thank you so much.
Hi, I'm Mohamed Abdurrahman Ogle. So now we are going to transit our third crucial issue, which is a health and safety issue. This issue is concerned about our company for case study for Bright AD company. The central problem here revolves around a widespread disregard for workplace safety, leading to accidents such as twice unfortunate loss of 2 fingers due to a malfunctioning machine. The key question here is how to ensure the health and safety of workers in a scenario where safety concerns are consistently ignored by upper management, creating a sense of fear among employees. So let's dive deeper into this third issue. To address workplace safety challenges, we will be examining relevant regulation in India, especially the Factories Act of 1948 and Mines Act of 1952. These regulations cover various aspects, including working conditions, safety measures, and accident prevention. However, the case study highlights a deficiency in this regulation covering informal sector of workers and the absence of safety training and also equipment, also major contributing factors to workplace accidents in India.
If you truly believe that safety is important in your work, at home, or anywhere else, there is no place for these two phrases, safety first and safety is our number one priority. To do a job safely, our goal is to complete it without accident or injury. But the slogans safety first and safety is our priority will not help us achieve this goal. The danger in making safety a priority rests within the reality that priorities get reshuffled throughout the day. When we're under pressure to complete a job, we may find that safety first can easily become safety second, safety third, or moved so far down the list that we end up taking ridiculous risks that result in accidents. Your employer is not in business to make you be safe or to keep you safe. There's no doubt that they want you to go home safe and healthy every day, but the company's priorities revolve around different goals, just as your goal is to make money in the form of a paycheck. Slogans like safety first and safety is our priority discourage personal responsibility because safety begins and ends with you. Is it reasonable to think that someone would hire you to do a job and then tell you that nothing is more important to them than your personal safety? Of course not. All sorts of jobs, ranging from easy and relatively safe to difficult and dangerous, are done by people who are willing to assume risk. It is true that your employer does not want you to get hurt. It's bad for business, it's bad for the customers, and it's bad for the bottom line. No one wants their employees to get hurt. Therefore, most workplaces have some safety policies and procedures, all with your safety in mind. But they cannot force you to make safety first or to make it the priority in everything you do. The employer isn't your parent and you're not a child. The key to safety is personal responsibility. Hazards and various degrees of risk from hazards are everywhere, and they cannot be completely eliminated. On the other hand, hazards can be known and they can be understood. Every task you do has to be approached with varying levels of hazard awareness. You can look for and understand the hazards in every job, or you can ignore them. Your job can be approached with care or with a lack of care for safety. All of that is going to be up to you. Don't rely on cute little phrases to make you safe. Rely on yourself. Remember, the key to safety is personal responsibility.
Well, as we dissect the intricacies of occupational health and safety issue, we will touch upon the better need for training, legislation, and also methods. Let's move on the last part of our case study. So thank you for being part of this legal exploration.
My name is Wiye Sonko, and now we have reached to the fourth and the final issues of our comprehensive examination of legal challenges within Brighton AD company case study. Whether Bright Act action, which includes selling customers information without authorization and violating users' privacy law, violation the Information Technology Act 2000 and the Information Technology Act 2008, and hence having legal ramification under Indian law protecting privacy and data security. Section 72 and Section 72A of the Indian law under the Information Technology Act of 2000 provide criminal penalties for violating data privacy or legitimate contract. Section 72 of the Act establishes liability for breaching of confidential and privacy, while Section 72A establishes liability for disclosure of information in violation of legal contract. Act 72 and 72A of Indian law state that a person or organization, including an intermediary who has secured access to any material containing personal or organizational information about another person or organization while providing service under the term of law of contract, with the intent to cause or knowing that he likely to cause wrongful loss or wrongful gain, disclosed without the consent of the person or organization concerned, shall be punished with imprisonment for the term of 3 years or a fine of 5 lakhs, which is approximately equivalent to $6,000.
Hi, Mac. How are you?
I'm good, thanks.
You look nervous.
Well, it's going to be mine and Lindsay's 5th year anniversary since we started dating. I'm trying to plan a special evening for us.
5 years? Congrats! Are you proposing?
Ha ha. Not at the moment. Oops, I need to get back to work. Have a good one, Cindy.
You too.
Wow, $10,000. That might be a bit rich for my blood, but maybe it's time to get saving. Oh well, time to move on to other things. That's weird.
So, have you been thinking about getting hitched?
Cindy, can you mind your own business?
Well, I saw that WeddingRings.com and Tuxedo World started following you.
That's strange. I checked a wedding ring website, and since then, I keep getting all these emails, text, and now Twitter followers about wedding stuff.
Did you have to create an account on the website you used?
Yeah.
And you read the website's privacy policy?
No, I figured it wasn't a big deal.
Well, just so you know, you should make sure to read the privacy policy next time. The site may have written in language to share your information, which is why you're getting those messages.
Oh, I'd better go back and cancel that account before Lindsay starts seeing all of these wedding ads. Uh-oh, Mr. Timmons wants to see me in his office.
Well, good luck, and remember to read the fine print.
Our analysis mainly focuses on legal framework available to address violation of data privacy and its consequences to those who engage in such actions. As we stay with us as we wrap up our presentation. Thank you so much for your kind attention throughout our presentation.
Here we reach the conclusion. So it's me, Muhammad Zubair. First and foremost, we would like to thank you for joining us today. As you can see throughout our video, we have addressed 4 critical issues, starting with employment discrimination, going to the worker exploitation. Thirdly, we have the occupational health and safety concerns, and in the fourth one we have the violation of data privacy, of user data privacy. So each and every issue of these 4 go along with the governing Indian law regulations. So starting in the case of Sarah, the discrimination that happened to Sarah, and the accident in workplace environment, and as we can see also the breach of data privacy, user data privacy. So in this video we hope we have provided you with the points that you need, and it was very useful for you. That is all for us, and on behalf of my team we would like to thank you again as you join us today. Stay tuned and see you soon. Thank you so much.